Hello and welcome back. In this video, I'm going to work through the ways in which technology, in particular artificial intelligence, because that's the focus of the text that you've been given to read, has been really reshaping the way that discovery, or pre-trial discovery in particular, is being done worldwide. But before we get into the technologies, let's actually spend a minute thinking about what discovery is. And as a consequence, if we think about what it is and why we do it, we'll understand better what the tools are, what it is that we are seeking to address when it comes to these tools. So I think the definition that's in the text that you've been given is excellent. Don't worry, you don't need to squint to read it on the screen or rifle around for the PowerPoint if you've got me in your ears on the podcast. I'm going to read it in an annotated way. So discovery might be called other things in different jurisdictions, but here we generally call it discovery or pre-trial discovery. Discovery provides a procedure, so a process or a way of doing things that allows a party to obtain information. So that information might be in the form of documents, witness statements, evidence, in other words, about a claim or a defense. So it doesn't matter whether you're the claimant seeking information about the defense or a defendant seeking information about the claim that's being made. So you can obtain information about a claim or a defense from the other side. Discovery increases the likelihood that a judgment or a settlement will be correct and fair. Now that's really important. The purpose of discovery is to increase the likelihood that the judgment or the eventual settlement will be correct and fair by facilitating the exchange of information, facilitating knowledge of the facts. The ability to inspect an opponent's documents places the parties on equal footing and avoids trial by ambush. So let's unpick what that means. I think television and movies, as much as I love a good legal drama just as the next person, they really do us a disservice. It's like within one episode, sometimes, I used to love Law and Order. I haven't watched it for a while, but the first half of the episode, they solve the case, and then next thing you know, we're in trial, and the guy who ended up married to Lily Tomlin in a completely different show is, waxing lyrical and making very excellent points, and the whole drama is played out. Actually, and you know that there are a lot of complaints about the length of time that it takes to get a matter to trial. And there are some really good reasons why there should be speedy trials. I'll talk about those in a second. But it's not as if nothing is happening in the time between a claim being made or an allegation being made and the matter being brought to trial. This discovery process is an important part of the justice process because it is all about facilitating that fairness. But at the end of the day, we've seen over the years significant issues with the way that discovery had been conducted. And so a no stone unturned approach or a fishing expedition approach are just some of the tactics that were used often to increase costs and increase delays. Now, this happens for a range of reasons which might actually sit very well with your adversarial advocate or zealous advocate ethical framework that people work within. There are some really good examples. Let me contextualize this for you for a moment. So back in the 80s and 90s, there were a lot of cases brought by seriously ill people against tobacco companies. Now, the law firms that advised those companies were very well known for using tactics that would delay a matter getting to court. And there are a range of reasons for that. One is actually as kind of outrageous as if the defendant was found to have some contribution to that ill person's illness, the amount that would be payable following the death of that person would be significantly less in most cases than what might need to be paid if they had to support that person in some way and their medical bills over time into the future. That seems really callous to say it that way, but it's a perfectly legitimate approach in certain contexts. Even when we're not talking about, it's really easy to be kind of dark on the asbestos companies or the tobacco companies, but there can be really good reasons, even in smaller commercial matters, for delaying the outcome. In many jurisdictions, the USA, for example, there isn't a right to cost. So if somebody brings an unfounded piece of litigation, one of the tactics that will quite commonly be used is to really go hard early, lots of notices, lots of discovery, and really try as much as you can to kind of defeat them early in the process. Hope that the delays and the time and the cost that is involved will help them make a decision that their case is also weak. Now is the time to pull out. But in jurisdictions where there's very little incentive to not bring litigation, in the sense that there is no culture or rule that allows cost orders to be made, then you can see that going in hard really makes a lot of sense, particularly when there is when there isn't a strong case being made against you. So when we think about what the lawyer's work is here, it's essentially, notwithstanding these tactics, the lawyer work is essentially finding and producing the most relevant documents. And over time, as courts have responded to these increases in costs and delays, we've seen court rules that specify the scope of the cover or of the scope of the discovery, and then followed on by the legal work, which is really about collecting and collating the materials that fall within that scope that are directly relevant, or responding, reviewing and operationalising that review process. Now, we're not just talking about Australia here too. It's really important to understand that discovery or versions of discovery are also relevant in civil countries and to arbitration and to regulation. So this kind of approach is being used all the time. The rule that you probably can't see on the screen because you would really have to squint, go and have a look at the slide later, or even better, just look up Rule 20 of the Federal Court Rules, really sets out what it are the rules in a federal court situation for the discovery of the documents. And you will see here that the court orders a party to give standard discovery. That means that the party needs to produce documents that are directly relevant to the issues raised by the pleadings, of which, after a reasonable search, they're aware of. So they need to undertake some kind of reasonable search to become aware of them, and that are or have been in the control of that party. So there are a range of criteria. So at least one of the criteria in Rule 20.142 needs to be there. So it needs to be a document on which the party intends to rely, a document that adversely affects their own case. So you can't just hide away the stuff that might actually prove that the other side have a better case than you thought. You need to produce all of the documents to ensure a fair trial, documents that support the other party's case, and documents that adversely affect the other party's case. So you can't just limit to category D there. So it's become pretty important to understand what directly relevant means. Key cases are on the slide. So Construction, Forestry, Mining and Energy Union against BHP's Coal. I said against rather than and, just to make sure you could understand the case I was looking at. But the citation is on the slide there for you. There are a couple of other cases, including a federal court case in 2018, Adelaide Brighton Cement, in the matter of concrete supply and concrete supply. Basically, it's pretty clear that directly on point means, or directly relevant means directly on point. But only one of those 4 criteria need to be addressed. So the criteria that documents support another party's case has been considered and interpreted as meaning strengthening a position, contributing to success, preventing failure, or corroborating or substantiating a claim. Have a look at Dennis and Chambers Investment Planners in relation to that. So the Australian Law Reform Commission, in its review of the federal court rules, noted that many organisations do not have systems for managing records, and as a consequence, lawyers need to operationalise or create a system for finding the right records, especially when you think about how many records are electronic these days, before any kind of review can commence. And so this is where technology-assisted review, or TAR, comes into place. So in that report that I mentioned, sorry, I think I should have stopped mentioning it and moved to the next slide, the ALRC, the Australian Law Reform Commission, said, in almost all studies of litigation, discovery is singled out as the procedure most often open to abuse, the most costly, and the most in need of court supervision and control. So as far back as 2009, the Access to Justice Task Force, now just listen to that name, Access to Justice Task Force. This is all about making the proceedings fair, which is balancing, let's make sure that we get all the right documents out in the open here, all of the right records out in the open. But at the same time, the process of doing so shouldn't be so cumbersome and so expensive that we're going to drown in the discovery process and not see justice at all. So think about it from a justice position. This is what we need a tool to do, is to help us achieve justice. So in that report, they said discovery is most often the single largest cost in any corporate litigation, yet it remains an important feature of the common law cases. Why is this? In large part, it's because what we understand to be a document has significantly changed in recent years. So again, I've got a couple of cases on the slide here for you, and there is value in having a look at them. So since 2016, the Supreme Court of Victoria has really led the way here in saying, in order to actually achieve this balance between the requirement to surface all of the required materials, but also not drown the parties in unnecessary and complex process, is that we should be using technology tools as much as possible to reduce that task for the humans involved. And since 2016, well, it actually became effective in 2017, the Victorian Supreme Court practice notes have essentially said that hard copies should be the exception, not the rule, and that people need to justify why they need to convert any electronic documents into hard copies. Gone are the days of seeing people wandering down streets in Melbourne with their trolleys with many, many folders in them. You still occasionally see them on the news, actually. I find this kind of odd, but anyway. It's really become clearer and clearer that in large cases in particular, technology-assisted review will be an accepted method of conducting discovery, and the court can order discovery by technology-assisted review irrespective of whether the parties are happy with that or not. So what is technology-assisted review? This is basically what your reading focuses in on. I've given you a couple of brands there. Law and Order and Xero are both Australian companies who are significant providers of these technologies. And I think one of the best ways for you to get a sense of what it is that TAR is, what in fact technology assisted review does, is to go and have a look at their websites, quite frankly, so Law and Order or Xterra, and see how they are doing the things that they do. They use a lot of algorithms to do this, so there is a lot of kind of, it's a lot more than just sitting find F, bunny ears, smoking gun. Unlikely to get you very far in a massive litigation, but with complex tools, that's essentially what they're doing. They're looking for the smoking gun. So they do, it is actually in some ways as simple as let's find and categorize all of the documents that fit within a particular topic, that touch on the topic that is the subject of this piece of litigation or this potential crime. It also does a lot of sorting and removal of duplicates. So I know you guys, hardly anybody uses email anymore, but old people like me are quite familiar with email. And if you're going backwards and forwards with somebody, you're sending emails and the chain gets longer and longer and longer at the bottom. It's not like using Teams or Slack or Zoom chat to have a conversation. You're basically getting conversation repeated. And you can't always tell whether somebody's changed something in the bottom or not. Technology-assisted review programs will go and look at the email chains and they will identify everything that was in the conversation. They will identify the things that might have changed or that might have been varied in some ways, in ways that will help the lawyers really identify which are the one or two documents that are most important here. Also, when you think about the way that people create drafts and they pull things up, you can end up with these massive version control issues, and they really are quite good at creating a kind of timeline or a chronology of events and really lumping in the most relevant documents. Now here, when I talk about documents, I'm using the Electronic Transactions Act type definition. A document is anything that can be reduced to readable form. Now those readable form may well be, zeros and ones. This video is a document as far as the law is concerned. My phone, which is beeping away like a crazy thing at the moment, I don't know who is texting me, the text messages, the WhatsApp messages, the emails, possibly even the metadata about how often I play that silly game where you line the dots up, or Tetris or Wordle, all of those things are documents. Your Tinder profile, whatever it is, Bumble, whatever you're using, is a document. And so that expansion out into all of the things that we are looking at, all of the ways in which we communicate, not only with text but with voice and images as well. Technology is basically algorithmically trained to explore and to find the most or find the best work that it can there. So this image basically comes out of the text that you're asked to read, and I just wanted to highlight it because I think if we go back to Richard Susskind and we go back to that idea of decomposing or unbundling legal services, we can see that the role of lawyers is not reducing as a consequence of the involvement of technology-assisted review or the opportunity to use technology-assisted review. If anything, it actually means that lawyers no longer have the luxury of just clocking up time reading documents and highlighting bits of them and then making serious arguments about what should be included or excluded from discovery. Instead, actually, they are elevated very quickly to the strategic point. So lawyers really have very important roles in relation to the whole electronic document review process. It's much more than just getting to that analysis stage where the technology-assisted review is deployed. Rather, it's involved in setting up the whole strategy at this point and really understanding what the search terms need to be and what it is that you are looking for. In a haystack, everything looks like a needle. And when we're talking about a machine that you are training to find things, how do you describe a needle in a way that is going to reduce the number of false positives and increase the chances of finding that smoking gun? So read the material carefully and really do your best to try and understand what it is that technology-assisted review does, and then think about what that might mean for your experience in practice. The other thing I wanted to bring to your attention here is the rules in the Civil Procedure Act, and in particular Rules 7 and Rules 8, which make it very clear that courts themselves are moving or have moved to technology as a starting point. So electronic documents, paper documents are out. Electronic documents are everything. Everything is filed electronically. The court can require you, if you only got paper documents, to actually go to the expense of having those documents scanned and made subject to optical character recognition, OCR technologies. That's getting easier and easier. Like, you can point your phone at something these days and it can read anyway. It is also incumbent upon the parties to think about the ways in which technology can improve the process and reduce costs. And it's also made very clear in the rules, in Rule 8.7, that technology-assisted review is an accepted method of conducting a reasonable search. So there's really no controversy about any of this now. And I think it's really important to stand back again and just keep remembering that what we are talking about here is justice and trying to balance an approach that has been created over many years to provide for the surfacing of everything that is relevant so that somebody can have a fair trial, and the complexities of dealing with documents or evidence in an increasingly changing world. So ultimately, when you're thinking about the technology, don't resist the urge, I guess is what I say, to think about the technology for the sake of the technology. Always stand back and think, what is the purpose? What is this for? And is a technology the best way of doing it, or is there something else? Now, when we're talking about large-scale litigation, technology-assisted review has made significant inroads and really is a significant player in this space. What does that mean for you? It means that being able to think about the way that sophisticated artificial intelligence-driven software might work to help you find that proverbial needle in the haystack will be really important. So that's all I've got to say about this one. Let's hope the next couple of videos are a little bit quicker because we've got some of the background material. Thanks for your time and attention. And as always, questions, concerns, frustrations, and compliments, don't hesitate to put them on Canvas or send me an email.